only to put him deeper into debt.
Sure. But now, I'm in this now. What do I do? How can I get out of this?
There are few methods to attend to. The first one is to settle the debts and get a clearance certificate, which is the most common one. When you have a clearance certificate, obviously you don't need to apply to court.
Okay.
Then the other one is obviously you must apply to court and make a court application.
Okay.
So that you be removed from debt review, because it's very easy. Debt review is like an arrest.
Yes.
It's very easy to be arrested, but it's very difficult to be released.
I actually said that to him. I said, the sad thing is it's easy to get into debt review, but very difficult to get out of it.
Very difficult. But you can apply to the magistrate court.
As a regular citizen, or do you need a lawyer for that?
You obviously need a lawyer.
Of course.
Yeah, who's going to draft the papers for you?
Okay.
Yeah, you can make an application in terms of Section 87, subsection 1A of the National Credit Act for a court order to remove the flag.
All right. But let's say this is an unemployed person. How would you advise for them to go about this? Because right now, and apparently, they even threatened him. So he says he blocked them because they would call him at like 9 p.m. at night. And he says they threatened him, told him that he wouldn't even get a job from this. And so now I think that's what got him worried, because he is looking for a job. He's unemployed.
Yeah, and you see, there's certain times, Lukho, when these collectors are not supposed to call you.
Told him exactly that.
You see,
told him exactly
that. A debt collector cannot call you on a Sunday.
7 p.m.
After 7 p.m. You see, there's certain instances where they are not. So in such instance, then you can get them reported by the Council of Debt Collectors.
Oh, okay. So he can document that he was called at a certain time, he was harassed, which led... Because remember also, Mr. SK, you're calling me, I don't know you.
Yes.
You're calling me at 9 p.m.
At night, yeah. And
I understand that you may have gotten the date somehow, but at 9 p.m.,
yeah.
And when I block you, I'm put under debt review. So yes, he may report them, but I want us to get to, now he is in the debt review.
Yes.
He is unemployed. What does he do? Is there any remedial action that he can take?
Can approach a debt counselor.
Okay.
Yeah.
All right.
Then obviously a debt counselor will do what we call a financial assessment.
Okay.
Then, or either he can go the legal route.
Okay.
If he has financial muscle to pay the lawyers, of course. You see, then that's basically that. It's either to approach a debt counselor, then they will do a financial assessment and take a matter to court and get that particular debt.
But are these not the very same people, a debt counselor, that got him into debt review?
No. He was put by debt collectors.
Or debt collectors. Now he needs a debt counselor.
Or lawyers, yes.
Or lawyers. I see where you're going with this. All right. Okay. So because look, there's a lot of people in a similar position. That's just the thing.
Yeah.
There's a lot of people in a similar position that need to get out of this. Okay. So let's get into sick notes. I think we would not be doing justice to today's conversation if we didn't address what we had promised to address.
Yes. You see, Lukho, there's instances where employees, they would submit sick notes, not for purposes that they are sick. Especially, I want us to take it this way, in terms of employees that are subjected to disciplinary hearings.
Okay.
Where they can see that decision in the disciplinary hearing may not favor them. Then in instances like that, you'll find them having to submit sick notes to delay the process, because most of them, you'll find that they are actually suspended with pay. And to prolong the process so that they must continue.
Keeps them in the payroll
and so forth. Then they will submit a sick note just to delay the process. Then what I want us to look into, the legitimacy of a sick note. How does the law view a sick note?
As legit.
As legit.
Okay.
You see, then in this instance, we're going to look in the case of Mugobozi versus Naidu. Yeah. You see, this is the case that Lukho tells us clearly about how legit a sick note or how acceptable a sick note is to an employer.
Okay.
You see, then in this case, what happened, Lukho, an employee was under disciplinary hearing.
Okay.
And that employee realized that decision, I'm going to be dismissed.
Okay.
Then he approached a doctor, submitted a sick note. Subsequently, he was dismissed.
Sure.
And approached the CCMA to say I was unfairly, obviously, every employee when dismissed, they will say they are unfairly dismissed. Yes.
Which often happens, but okay.
yeah. You see, so after approaching the CCMA said no, the dismissal was actually fair.
Okay.
Then this employee further went to the labor court. Remember, it's a procedural aspect that from the CCMA, you must go to the labor court. You see, so it went to the labor court, and the labor court also ruled that no, the dismissal was actually fair. Then the other decision, that was the labor court. Remember, the labor court carries the stature of a high court.
Yes.
Where it is judges that presides in the labor court, not magistrates. You see, so...
Oh, really?
Yeah.
Okay.
So what was decided there was decided to say medical certificate, it's hearsay evidence because it is made by another person.
Of course,
which
makes sense.
Made by the actual employee.
So in other words, okay, no, this is going to hit me.
I don't know if you get it.
I get it. I hear it because I told you how I feel. So basically, it can't be on the basis of surely Lukho was sick. Because Lukho could have gone to Dr. Seakamela and said, I have a headache and there's a sick note.
Yes.
But what I want to understand, I'm going to come to a question here now, because now this is hitting me.
Yes.
But in the event that truly I was sick and an evaluation was made, what needs to happen? What does the medical personnel need to do in order to support the claims that truly I was not well? When is then a sick note valid if it is considered as a hearsay?
A sick note is never a valid document if it is not supported by a supplementary affidavit. So the doctor must make a supplementary affidavit, especially where an employee is subjected to
such processes.
To such a process of a disciplinary hearing.
Okay.
So in the sick note, hence one of the important issues in this case that I've mentioned is that sick note must be scrutinized. And scrutiny around it, we check the following. It must state clearly that this employee is sick due to 1, 2, 3, and cannot be able to attend a disciplinary hearing. It must make mention of that. Okay. You see, so most of the employees, they will go...
So sorry for cutting you. So there's a difference between it stating that I cannot be at work and it stating I'm not fit for a disciplinary hearing.
Yes.
Because it could say not fit for work.
Yes.
But even if you went, you could survive a disciplinary hearing. Is that the argument in place?
That is the argument in place.
Okay.
Because most of the time, for the employer to be able to investigate, they would suspend such an employee.
Okay.
To say, no, you are suspended with pay, stay at home until we are done with investigations. Then we will be able to decide.
Okay.
Or the chairperson of the disciplinary hearing will decide as to whether dismissal it's a correct decision to make or not.
Okay.
So that's basically what will happen. Hence, such a a sick note must be scrutinized. That's the first thing.
Okay.
You scrutinize it, you check as to whether does it address the issue in place. Because it can speak about work, it can speak about you not being able to attend the disciplinary hearing. So in this case of Mgobozi versus Naidu, the most acceptable process, the sick note must state that the said employee cannot attend the disciplinary hearing.
Okay. Satisfied.
You see, so hence such evidence does not stop proceedings. Most employees, they think, I'll just get a medical certificate submitted, then the disciplinary hearing will not sit.
Okay.
You see, only to find that the disciplinary hearing can still proceed with or without you.
Is there a period then or a window that's given to me as an employee who has brought a sick note because they were genuinely sick? Do you then guys go back and say, we get the sick note, but we need supporting evidence? Or do you literally automatically take that sick note and dismiss it on the basis that it is missing of these particular details that you require?
You see, look at the importance of relying on precedents or decided cases.
Okay.
It's what happened in the case of Mgobozi. You see, so the sick note must, in all material terms, be scrutinized.
Okay.
Because it's a trend that employees will often submit medical certificates just to avoid the process of disciplinary hearing.
So what you're saying is any employee should be under the knowledge that if they have any disciplinary against themselves and happen to visit a doctor, they need to disclose to the doctor so that the doctor makes a judgment on whether or not they are ready to appear for the disciplinary hearing.
It must be explicit.
So it is then my responsibility as the suspended person to give brief to my doctor so that they decide whether they want to put themselves in the line of law to say Lukho is fit or not.
Yeah, you see, the principle of honesty, Lukho.
True.
Same as when you consult a lawyer. You need to be very open and honest.
Yeah.
To say these are the circumstances. Because there's no way that you can be helped if you are misleading the person that you expect help from.
True.
Same with the doctor.
So that when they make the note, they are ready to stand for the claim they've made in that note.
Yes. You see. So there must be clear to say this employee or this particular person approached us with this condition, and this condition makes them not to be able to attend the disciplinary.
Okay. Fair enough.
Because it's not automatic. Most of the employees, they think that it's automatic.
That once there's a sick note, you're off the hook.
Then you're off hook.
Okay.
You see, and it is not automatic. Dismissal may still be fair.
Okay.
Because remember, there's just a few things that we look into, especially into labor law. The procedural aspect. Was the procedure correct? Was the procedure correctly followed? Was the law correctly applied?
Okay.
Then from there, I mean, we speak of dismissal, because that leads to dishonesty.
Exactly.
You see, when an employee goes to a doctor and say to a doctor, "Give me a medical certificate for purposes of me avoiding a disciplinary hearing," that's dishonesty.
And Malika is that whoever the doctor is must be ready to face the music for their claims as well.
Exactly, because that's also a fraudulent activity from the doctor's side.
Sure.
Hence, we speak of the corrupter and the corruptee.
Yeah.
You see, where one gives gratitude and one receives. Because the doctor at that instance is looking at his
the
pocket.
gain, exactly.
To say this patient came, they allege they are sick. Then I issue out a medical certificate for that purpose.
And I guess it's kind of fair, Mr. SK, because if I should bring such a matter to you and expect you to declare me too sick to stand my trial, then I am inadvertently saying risk your job for me.
Exactly.
And any sane medical person who stands to lose their license will not agree to such a thing.
Exactly. And that's also ignorance, Lukho, to company policy. Because every employer has got a policy.
Yeah.
To say if you are subjected to disciplinary, you must in all material times attend. So the minute you do not attend, you are actually in violation with the policy.
Of course.
Before we even speak about the law and labor law and so forth.
True.
We speak about the company policies. So one will be now start to be in violation with the company policy before being in violation with the labor law. Because dishonesty, there's no employee that can take dishonesty.
Of course.
And if you submit a medical certificate while you are not sick, that's dishonesty. And it qualifies a fair dismissal.
Yep.
You see, so in this case has set a very clear precedent that you face your consequences if subjected to a disciplinary hearing. You go and adduce your evidence.
Yep.
Then obviously there is impartiality that is in all material times expected from the chairpersons of the disciplinary hearing.
Yeah.
You see, because dismissal in all material times must be fair. There's no way that dismissal can be unfair. Because one, what makes dismissal to be unfair? Lack of warning, not giving an employee prior warnings.
Okay.
Chances to improve.
Okay.
You see, so those are the prerogative responsibilities the employer has.
All right.
Let's say here, Lukho, we're dealing with an employee that has a drug problem. Before an employer can dismiss such an employee, they must make sure that they subject such an employee to professional people that can try to assist in that particular problem. If such does not occur, then any dismissal that may arise as a result of that will become unfair.
Unfair, yeah.
Because they have, when you employ a person, it's like when you give birth to a child. You must make sure that that particular child, you teach them
well taken care of.
You teach them rules. You teach them how they must behave. Same in an employment space. Employer has got a prerogative responsibility to teach employees how they must behave in the employment space, how they must conduct themselves in the employment space.
Yeah.
You see, so such responsibility lies in the hands of the employer. Then again, the employer must have a clear policy that outlines consequences of if you do this, this will be the consequences. And there must be an open communication between employer
and the
employee. Then should the employee be subjected to a hearing, the hearing must be fair. The chairperson of the hearing must be an impartial person. Shouldn't be the person that is going to take side of the employer.
Okay.
But it's common cause.
I was about to say.
Yeah. It's common cause that, employer has got an upper hand because
and they choose the chairman who has their story already.
Who has the
Let's
story
be
already.
realistic about it.
Yeah, that is the case. You see, so you find that even such conduct, hence an employee has a right to apply for recusal of the chairperson.
Okay.
In the disciplinary hearing, because most of the time, actually not most of the time, in all material times, the employer is the one that employs the chairperson.
Of course.
And remember, the employer has got a good financial muscle other than the employee.
Exactly.
Then you find that employee cannot even afford legal fees.
Representation, exactly.
Or maybe not satisfied with the union rep. Because remember, in a DC, you must be represented either by a colleague, a union rep.
And let's also be realistic. A lot of private corporates actually, and it's quite a thing of late, they don't have unions.
They don't have unions.
Yeah. So the chances of an employee being prejudiced are very high, realistically speaking.
Yeah, very high. Hence, there's congestion in the labor courts.
Sure.
Because people are appealing decisions that were made by chairpersons of disciplinary hearings and so forth. You see, so sure. It's very important that listeners be aware that it's not necessary to delay a disciplinary hearing by submitting a medical certificate for the sake of being on the payroll. But it's very important that one should go and submit or hand over their own evidence.
Yeah.
Then
even if or when you think the process could be unfair towards you,
even if you feel
go
that
through the process,
go attend the process, because that is one of the gesture that the chairperson will also look into, to say this person does not attend a disciplinary hearing. Subsequently, this person is sick. Then it raises eyebrows in the eyes of the chairperson. To
can imagine
this person was healthy, working.
And then all of a sudden,
this person is submitting a medical certificate.
I can imagine the most common reasoning is always that the person is depressed, yes, and anxious because of the whole situation.
Yeah, the situation obviously, Lukho, will depress you.
Yeah, true.
Yeah, with experience, I've seen people collapsing.
Really?
In disciplinary hearings. Yes.
Really?
Especially after ruling is
I was about
granted.
to say, if that's probably the most common when ruling is given.
Yeah, because there's a lot at stake, Lukho. When you listen to the mitigation factors and the aggravating circumstances from the employer, when you weigh them, you'll realize that the employee actually will most plead that I've got a family, I've got kids, I've got property to pay, I've got rental to pay.
Yeah.
You see, so those circumstances are the ones that will lead them to depression.
Okay.
Hence, we will always advise employees to behave in all material times.
And think of all those things that will be affected should you actually lose your job.
That you may suffer due to the love of or maybe even the love of money. Yeah, there's a personal case that we did in Polokwane of one traffic officer. This guy was allowed to go home with the employer's car.
Okay.
So when he's broke, he will go and do what's this?
Uber.
No. He will go and do a roadblock. Remember, he's
very, very common that one. I'm not shocked. I was shocked there for a moment.
Remember, he's got uniform. He's going with the car home. Then he will go to a roadblock somewhere and stop people. Then now he will shock these people that this person does not take action against us. Always he's bargaining for money.
And he goes there alone, or does he have another colleague?
No, he will take maybe like us, you see.
And give you alternative uniform.
The legal junction team, you see. I've got a police uniform that I give it to you.
Sure.
Then we stop people and request money.
Sure. I'm not shocked. 2022, was it November? No, October. A friend of mine and I were driving back from somewhere in the Northwest, and we had booked accommodation here at Midland, Maine. So we're driving back together. We had just dropped somebody from Northwest, and on our way back, a traffic cop stops us. I can't even remember where we were.
Yeah.
We stop, and we're not in high speed. My friend drives a proper car, and we're like, "What's happening, friend?"
Yeah.
He walks up to us. He looks at the car. Everything. It's a brand new car. I think the car had just been bought that year. That was one of these R-Line VW R-Line T-Rock.
Yes.
And so this guy realizes there's nothing wrong with it, and then he says, "Can we give him a cool drink?" We have Red Bull in the car, and my friend turns around, takes the Red Bull, gives it to him. I could see how puzzled he was.
Yeah.
My friend's like, "Okay." And then he lets us go.
Yeah.
So I look at my friend. I'm like, "Hlahla, what did you just do?" She's like, "What, friend?" And I'm like, "He wanted money."
Yeah, no, that's the honest. That's the honest.
My friend was like, "You're sorry, Chomi. Well, I thought he really wanted cool drink because I've done nothing wrong."
Yeah.
So I really thought he wanted something to drink.
He was thirsty.
But imagine stopping a car just to ask for something to drink. Really?
You see. So it's very dangerous, Lukho.
Yeah.
Hence, First Timothy. You know, here on the legal junction, we speak law. Scripture.
Come on.
Yeah. 1 Timothy 6 verse 10. For the love of money is the root of all kinds of evil. You see? And this is what makes most employees to lose their job.
Yeah.
Because of this book of 1 Timothy 6 verse 10. Before we even look into the law, we look into what does the word of God says.
Yep.
Then we go to the law.
Our moral compass.
Yep. Then it will guide us. Because, you know, before the law was written, Lukho, the word of God was there.
Yep.
God existed before anything existed, before even sections and legislations existed. You see, so that is what makes people to lose their employment space, to submit fake medical certificates because of they do not adhere to the word.
Sure.
I think sivale kanjalo.
All right. Mr. SK, it's really great. I'm glad you fulfilled that promise.
Yeah.
Because we needed to actually address it. Because oftentimes I think we don't realize that some things are just, we know, but I think we take for granted just how corrupt some acts are, actually. Because you think you're trying to save yourself while you're digging yourself deeper into trouble.
You see, it's 1448. Maybe at 1530, someone out there was willing to go and get a fraudulent medical certificate. So we're here on the legal junction to say, don't do it. It's not good for you.
Don't do it, my friend.
Yeah, don't do it.
Okay.
Not good for you.
Time to sign out.
Sign out. From myself, the only lawyer of the radio. We meet in same time, same place, Radio Pulpit, next week, Thursday. God bless you.
That's it from myself, Lukho Mkwedi Phuthi. Until next time, have a super blessed one.